Salam Sejahtera Doctor, we are Group 6. Today we would like to present about our assignment, which is unfair dismissal in the modern workplace, legal protections and employer obligations in Malaysia and the United Kingdom. These are our group members. We have 5 people in one group. So for the introduction, unfair dismissal is someone fired from their job without reasonable cause by not following the legal steps for ending a job. It examines how employers in Malaysia and United Kingdom should comply with laws against unfairly dismissing employees. This study of the Employment Act 1955 and the Industrial Relations Act 1967 in Malaysia, and also the Employment Right Act 1996 and key case precedents in United Kingdom. This report investigates the principles and laws connected to unfair dismissal, compare the system in Malaysia and United Kingdom, deals with business and legal implications, and highlights the new issues on the subject.
Good afternoon, Doctor. My name is Chui Ning from Group 6. Today, I would like to present about theoretical and legal framework. Fundamentally, it is about upholding justice, contract law, workers' rights within the employment relationship with a strong emphasis on mutual trust between the employer and employee. This entire framework is rooted in principle of mutual justice, guarantee fair treatment and unbiased judgment for all. It is crucial to remember that employer cannot make unreasonable, accusation, or dismiss employee improperly. Any violation of this principle inevitably lead to claim for unfair or improper dismissals, reinforcing the need for fair treatment and the right to respond for. Next, I would like to talk about side layers, case and status regulatory guideline in Malaysia and United Kingdom. First is in Malaysia. Its framework is built primarily on the Industry Relations Act 1967 and the Employment Act 1955. A core principle found in Section 21 of the Industry Relations Act allow the employee to challenge dismissals lacking substantive cause. Furthermore, in Section 14(1)(a) of the Employment Act, mandate the employer follow fair dismissals procedures like evidence collection and investigation, with cases often going to the industrial court. Landmark cases like Goh Kiew Pon and Paul Darshini Janesen have solidified the burden of proof on the employer to justify the dismissal. Malaysia's 1975 Court of the Harmony Conduct in the Industry is guideline in Malaysia guide the discipline step, ensuring the employee can respond to the accusation. Now we move to the United Kingdom. The Employment Right Act 1996 is the main basics. Employee continuously employer for 2 years gain protection against the unfair dismissals. Section 94 of the Act require employer to demonstrate reasonable ground of dismissals, such as the misconduct or the overstaffing. Key case law like Pauki versus AE Dayton Service Ltd emphasizes that even if dismissals is unavoidable, a lack of fair process can still deem it unfair. The second case is the British Home Storage versus the Butchers case. Further reinforce the need for reasonable investigation. The UK's regulatory guideline is the ACAS Code of Practice on Disciplinary and the Complaint Procedures. In the next, I want to confidently navigate the fascinating differences and similarity in the legal framework surrounding unfair dismissals in Malaysia and the United Kingdom. From an empathetic perspective, understanding this distinction is important for anyone involved in employment, whether as an employee or an employer. For the first court aspect is main legislation. In Malaysia, the main legislation governing unfair dismissals is Industry Relations Act 1967. Contrastingly, the UK relies on the Employment Rights Act 1996 when it comes to protect minimum employment period. Malaysia generally has not fixed time limit for protection, and even during probation, employees usually go through an internal investigation. The UK requires 2 consecutive years of service for protection. Next, regarding dismissal process, Malaysia requires internal investigation for legal and fair reasons, while the UK follow the SEAS court emphasizing fair procedures. For remedies, Malaysia often provide monetary compensation or restoration, with the UK also offering the compensation or restatement. Layoff occurs in bond, by the UK has stricter procedures and often require extra compensation for the laid-off worker. In terms of discrimination protection, Malaysia has independent law through the FRAM method, while the UK's Equality Act provides comprehensive coverage. Essentially, Malaysian legal focus is on legitimate and fair dismissals, whereas the UK places a strong emphasis on protecting employee rights. I would like to present about the key terminology unfair dismissals that we need to understand. Firstly is unfair dismissals. Unfair dismissals means that dismissing an employee for unreasonable reason or without following proposed procedures. Next is a valid reason for dismissals is an acceptable or legally recognizable explanation, such as poor performance, improper behavior. We also have constructive dismissals, which happen when an employee resigns because employer's behavior becomes intolerable and making continued work impossible. Due process is the fair and reasonable procedures employer must be followed when dismissing employee, including investigation and hearing. The principle of neutral justice ensures all parties have the opportunity for appeal and a fair trial. Finally, reinstatement aims to restore unfair dismissed employees to their former job position, and the compensation refers to the monetary amount awarded to employees who have been unfairly dismissed. This is all for me. Thank you.
Good day, everyone. My name is Hotibul Umar bin Rohel, and today I'll be presenting the business and legal implications of unfair dismissal, with a focus on Malaysia and the United Kingdom. Unfair dismissal is not just a legal issue, it also impacts productivity, employee morale, and a company's public image. In Malaysia, the Industrial Relations Act 1967 requires employers to show just cause and excuse before terminating an employee. This means employers must follow proper disciplinary process like issuing warnings and conducting investigation. Meanwhile, in the UK, the Employment Rights Act 1996 and the SEAS Code of Practice require fair procedures and valid reasons for dismissal, such as misconduct, redundancy, or incapacity. So, workers are generally protected after 2 years of service. In this part, unfair dismissal laws has been strongly influenced business strategy and human resource management. In both countries, employers are expected to have clear HR policies and conduct risk assessments before dismissing the staff. Many companies has been consult lawyers beforehand to avoid mistakes. The legal and financial consequences can be serious. Therefore, in Malaysia, dismissed employees can be reinstated or awarded back pay if the court finds the dismissal unfair. Meanwhile, in the UK, compensation is calculated based on wages and length of service. Even if the financial caps are limited, legal fees and reputational damage can still hurt businesses. So we can see that a key UK case, such as Polkey versus A.E. Dayton Service, has been shown that even if the dismissal was justified, failure to follow procedures still makes it unfair. Let's look at some real-world examples. In Malaysia, the case Gun Kui Foy versus J&P Courts emphasized the need for solid evidence before termination. In the UK, the case was Midland Co-op versus Tipton has found a dismissal unfair because the employer didn't offer a proper appeal process. So we can see that these cases show that courts take procedural fairness very seriously. However, compliance is still a challenge in Malaysia. As example, in Malaysia, we can see that SMEs often struggle with documentation and legal awareness. Meanwhile, in the UK, employers must keep up with evolving issues like whistleblower protection and the rise of remote or gig work. In conclusion, employers must embed fairness and legal compliance into their HR practices. This has reduces the risk of legal action and supports a healthier and more transparent workplace. Thank you.
We're going to talk about the comparative legal analysis between Malaysia and the UK. For the first one is Malaysia. Firstly, the difference between the jurisdiction. Unfair dismissal in Malaysia is primarily governed by the Industrial Relations Act 1967 IRA and the Employment Act 1955 EA. Employees who believe they have been unfairly terminated can file a complaint under Section 20 of the IRA through the Director General of Industrial Relations. For a dismissal to be lawful, it must meet two key requirements: a valid reason, such as misconduct, redundancy, or poor performance, and a proper procedure. A key procedural requirement is the domestic inquiry, an internal hearing where the employee is informed of the allegations and given a chance to respond. Even if the employer has a legitimate reason, failure to follow a fair process such as skipping the inquiry or poor documentation can render the dismissal unfair and unlawful. For best practices, New Zealand and Canada prioritize early mediation and arbitration, reducing court cases and improving employer-employee relations. The European Union, such as Germany and Netherlands, emphasize clear performance appraisals and strong documentation, reducing legal risks. For Singapore, uses digital HR systems and transparent grievance procedures to build employee trust and ensure compliance. And Malaysia can enhance its system by strengthening conciliation services and investing in HR training to align with global standards. And the impact on international businesses, Malaysia's laws are stricter than those in countries like the US or UK. Both the reason and the process of dismissal must be legally sound. There's a high risk of reinstatement, which can disrupt operations. Foreign companies must adapt by seeking local legal guidance, training HR staff, and maintaining thorough documentation. Non-compliance can lead to industrial court cases, operational delays, and damage to reputation. A careful, conservative HR approach is essential for international firms operating in Malaysia. Next is the UK, the jurisdiction for United Kingdom. Unfair dismissal is governed by the Employment Rights Act 1996. Employees can usually file a claim after 2 years of continuous employment. Valid grounds for dismissal include misconduct, poor performance, redundancy, legal prohibitions, or some other substantial reason. The test used is whether the dismissal falls within the range of actions a reasonable employer would take in the same situation. The UK system generally favors financial compensation over reinstatement. This approach gives employers more flexibility in managing dismissals compared to Malaysia's stricter due process requirements. For the best practices, Scandinavian countries emphasize strong union employer dialogue and flexible work arrangements, promoting mutual trust. For the Australia, focuses on clear employment contracts and accessible online legal guidance, helping both employers and workers understand their rights. The United States uses internal compliance controls and external HR audits to reduce legal risks. The UK can improve by expanding the use of digital HR systems, encouraging early mediation in disputes, increasing employer training on dismissal laws and fair procedures. And the last one is the impact on international businesses. The UK's more flexible employment laws allow for smoother workforce adjustments. Employers benefit from less rigid procedures, but still must follow the ACAS Code of Practice to avoid legal exposure. Ignoring proper procedures can lead to high compensation awards, even if the dismissal reason is valid. Public sector organizations face extra pressure to maintain reputation and transparency. Global firms must ensure their HR policies are aligned with UK legal standards to avoid claims and maintain compliance.
Hi, my name is Nur Arifimran bin Noridman. So I will talk about challenge and future trends. For the challenge, there is 4 challenges in our case studies, which is workplace keep changing, struggle to comply with procedure, third is fail to follow the SS code, ACAS code, and last is lack of information about law. So for the challenge, I think the most difficult challenge for in this assignment, which is struggle to comply with the procedure, because there's much procedure that we have to follow during to our ACAS code, which is so many more important that we have to take note. So I think that's the most challenging. So for the next is future trends, which is there is a divide tree for our future trends assignment. Just first, influential patterns. There are some influential patterns that are expected to affect the loss and unfair dismissal with the HR process going digital. Also, it might retake a better records and opponents. So for the second is increasing number of people that trying to early dispute distribution, because unlike the methods like mediation, conciliation, which are well used in the place of our as for in the workspace. So for the last is stricter for whistleblower, part-time workers and independent contractors, which is now laws may be strict in the international businesses, so they must pay close attention to ensuring that this business is going smooth. Okay, so for the conclusion, the problems of unfair dismissals is still a major concern from both a legal and also the ethical perspective in Malaysia. So according to the report, both countries adopt policies to prevent unjust dismissals, but their ways, strategies and rules differ in this matter. For internal investigation and employment are crucial in Malaysia, but the UK mainly scales its process by paying compensation and following proper discipline. So the fair dismissals matter a lot to business and employees, as it plays a main role in maintaining the firm reputation, worker attitude, and following the rules. So for the lastly, the predictable ways to handle employee termination are more important than to make the relationship between the employer and employees fair and to maintain justice and quality at work. Thank you so much.